It's important to go to the objectives of it. Now, to highlight a few from a practical perspective, it's ensuring lawyers are competent and ethical. Now, how does that relate to practice management? Well, you've got to be able to run your business ethically. There's business ethics and there's legal ethics. The two of them sometimes don't mix. But it's making sure the lawyers are ethical, and if you're in a leadership or support role, just making sure that everything is ethical as well. Some of the key provisions are enhancing the protection of clients. Generally, when you mention clients in a context of regulatory issues with lawyers, there's lots of, well, we are within our rights to do these things, but over the years there's been a bigger push to protect consumers' rights, and this is just the furthering of that. I think it's the underpinning. It's not lawyers against clients, it's how we deal with our clients, deal with them properly. Another key objective, and this is written in the objectives, is empowering clients to make informed choices in relation to the services access and the costs involved. So there's a real emphasis on customer service, for the want of a better phrase. If you think who were involved in the drafting of this legislation, there were people from senior consumer organisations. So it is very consumer oriented. And we will talk about costs briefly. I'm not going to get into the discussion about what is reasonable, what's not. You'll all find that out later on. There are people who are far better qualified than me to talk about that. But when you're thinking about those areas and what you put in your cost disclosure, maybe what you put in your notifications, think about how the client feels. Just because you might be legally right to sue a client, maybe you shouldn't. Just think about the client aspect. And one final issue on this is, it's kind of through the theme, the obligations in the Act are placed upon legal practitioners and the law firm. That's a significant change from previous iterations of the Act, where it was really only on the lawyers. Then what happens is, I wasn't in the room. When he overcharged, I wasn't in the room, man overboard. So they're trying to put the obligations on the law firm. And as a practice manager or a interestingly called lay associate in a law firm, somebody who's not legally qualified, how do you then fit into that system if the obligations are on the law firm? The obligations could be on you as well.